Hi everyone, and welcome to another episode of Your Property Journey. Today we will be discussing the actual transfer process, and this refers to when you actually sign your agreement of sale or offer document and now it gets submitted to the attorneys. I will be chatting to two people from Ravenstein's office in Tiger Valley offices. First, I will be chatting to Christo Notnagel, and he will be giving us a very brief overview of the actual process. So, welcome, Christo. Thank you very much for being on my channel today. I really appreciate your time.
Thank you for inviting me, Colette.
Thank you. So, first, we will just need to ask Christo, tell us a bit about your experience as a transfer attorney.
Colette, I was admitted as an attorney and a conveyancer back in 2002, and ever since I've been employed by Gravensteins Incorporated in our Cape Town branch. We were first based in Adderley Street in Cape Town since 1998. We moved to the northern suburbs, Tiger Valley, in 2002, and we've been here ever since.
Okay, great. So just so that you do know, it's actually right next to the Metropolitan office. I'm sure many Cape Townians know where that is. Okay, next question. How long has the Tiger Valley office been in operation?
So the Tiger Valley office has been in operation since 2002, when we moved from the Cape Town, from Adderley Street.
Okay. Can you give us a brief description of the transfer process?
Yes. So the transfer process basically consists of three processes that run concurrently. You first got your transfer process attended to by a conveyancing firm. Then you have a bond cancellation attorney who acts on behalf of the bank and cancels the existing mortgage bond over the property. And then you've got a third attorney who registers the new mortgage bond for the purchaser to finance the purchase price. On the transfer side, the process basically consists of collecting all of the necessary documents, FICA documents, etc., securing the purchase price, the finances of the transaction, and then it consists further of obtaining the necessary clearances from SARS for your transfer duty exemption or transfer duty receipt. Also obtaining a rates clearance from the City of Cape Town, levy clearances from body corporates and homeowners associations, and then arranging lodgement at the deeds office. And lodgement is arranged between the different firms of attorneys. You've got your transferring attorney, bond cancellation attorney, and bond attorney, who all lodge simultaneously at the deeds office, and then it goes through examination process in the deeds office, and then after that registration follows. After registration, the transferring attorney will deal with the finances of the transaction and pay out all the parties. And that's the transfer process in a nutshell.
Okay, that's actually a lot of work. And it's shocking to me that now also leads me to the next other question I wanted to ask. Like sometimes a process can take very long and sometimes super fast. I know that recently you guys did a super quick transfer process for Kelserver. I think it was a month or two ago. How quick was that?
So we did that transfer in 4 weeks' time, but it is very difficult to predict how long a transfer will take, because in that specific instance there was no bond to be cancelled. The purchaser was a cash purchaser. The seller wanted to move out in 4 weeks' time. The certificates of compliance were completed, everything. So everything worked together to make sure, to ensure a smooth transfer in 4 weeks' time. And then, transfers can take very long as well. I've had transfers where we were linked to estate transfers, where there was disputes between the heirs, or where there was problems in obtaining letters of executorship, etc. And those transfers linked to our transfer would take very long, and then transfers take 1 to 2 years.
And that's like for a late estate, right? When one of the owners passes
away. Yeah. But there might be various reasons why a transfer can take very long. These days the banks are looking closely at building plans for the properties, and the bank, the purchaser might accept the property as it stands with illegal buildings on it, but the bank will not. And then the building plans first has to be approved for the transaction, and then it can take up to 6 months, even longer, for building plans to be approved, and
Sure.
then the transactions are
Yeah.
very delayed.
Yeah. Especially if it's some dodgy building and stuff like that, what it wasn't properly done.
Yeah, if the building was built illegally, then there's a lot of the time the roof might be too low, the roof pitch might not be right. The building might be built over the building line, so there might be a lot of things wrong with the actual building
Sure.
that prevents the approval of that.
So for instance, if in that case the buyer then decides to cancel that purchase, who is then liable for that cost at that stage?
If the seller is found to be in breach of contract, then the seller will be liable for the estate agent's commission and the wasted cost of the attorney. It will just all depend on the circumstances of the cancellation.
For sure. Okay. What are the kind of costs that buyers or sellers forget about?
Okay, sellers frequently forget about penalty interest payable in respect of their bond that is to be cancelled.
Okay, so
remember,
does that refer to if they didn't inform the bank that they are selling the property?
Correct.
Okay.
So the seller needs to notify the existing bondholder that they intend to cancel the mortgage bond, and the bank then they must give the bank 3 months notice of their intention to cancel.
Okay, 3 months notice.
3 months notice. And if we register earlier than the 3 months notice, then the seller will be paying penalty interest.
Oh, I see. Okay, so it has to be over the 3 months for you not to pay some kind of
penalty.
Okay.
The penalty.
That's interesting.
The penalty interest is the actual interest that is payable on the bond.
Okay.
Per month.
So would you say it is advisable to notify that you're going to sell your property before you even list the property? Because sometimes the property can get a buyer like on the first day that it's listed.
Yes, so the notice to the bank must be given by the seller as soon as possible.
Okay.
So while you're busy taking the mandate or listing the property, the seller should actually already have given notice.
Okay, so the next question on that, if they decide to give notice on that they are going to sell the property, and 6 months down the line the property is not been sold and they decide to take the property off the market, are there any implications then for the seller with the bank, or do they just let the bank know that they're no longer selling, or how does it work?
So that notice to the bank will just lapse.
Okay.
So the seller can inform the bank that they're actually not proceeding with the cancellation of the mortgage bond, or that notice can just lapse. It's very important that the seller also renews that notice to the bank, because it will differ from bank to bank. But that notice given to the bank, if the property does not sell within that period, then that notice has to be renewed with the bank.
And what is the average? I know you said it's different banks have different rules, but what's the average period that they give you?
I think it's around about 6 months.
Okay. Okay, yes. That's fair. Okay, great. Okay. Explain the different annexures. Now, I know this is can be a lengthy discussion. Maybe something that we could do at a next episode to go more in detail with the annexures, because I don't think a lot of people know, especially sellers, know about the different types of subject to sale annexures. Could you just give like a brief description or name a few of the types of annexures that normally would need to apply if someone is selling or buying a property?
Okay. Yes. So your first annexure, or the most common annexure to an agreement of sale, is the seller's mandatory disclosure form, where the seller declares the condition of the property. Okay. I think it's also referred to as a property condition report.
Correct.
And then there's also normally an annexure specifying fixtures and fittings to the property.
Okay.
There's normally a checklist which the seller completes where he confirms which fixtures or
Yes,
fittings
yes, yes.
are included in the property, and in that list they will also specify which fixtures will be removed.
Okay, yeah. We have that as part of our actual agreement of sale, yeah.
yeah.
So that helps.
A lot of the time it will be an annexure or it will be part of the agreement of sale.
Okay.
Then normally if there's not a 72-hour clause included in your agreement of sale, then there would be a 72-hour clause annexure as well. So the 72-hour clause gives the seller the opportunity to take multiple offers on the property.
Yes.
And then if the second offer complies with the suspensive conditions, then they can put the first offer under 72 hours notice to comply.
Correct.
And then further annexures are the purchaser might make the further annexures relate to the suspensive conditions applicable. So the suspensive conditions are normally the purchaser has to sell a property first. So it will be a subject to sale annexure.
Yes.
And also the seller might want to insert a condition where they make the sale subject to the seller actually purchasing a property. So the seller wants to safeguard his or her interest in another property.
Correct.
Okay.
Yes.
Yeah, and those are a few of the annexures, but there might be building plan annexures where we specify that certain buildings are not on plan. And the course of action which will be taken.
Yes. So would that refer to perhaps if there's a cash sale and there are no building plans and the buyer agrees to purchase the property on the premise knowing that there is no building plans and there's not going to be any comebacks afterwards, would that work as an annexure?
That would also work as an annexure. That could also be explained in the property disclosure report. Property condition report, sorry. But frequent building plan annexures which we do, or drafts for estate agents and sellers, are the building plan addendum that states that the building plans will be approved as soon as possible after registration, and that we normally retain funds as security for the seller's obligation to have the building plans approved.
I see, understand. And would there also be annexures like subject to the seller finding another property, a rental property, those type of things as well could also be added?
Yes, that is added. Yeah.
So it's just
that
to
will
cover
be subject
everyone.
to purchase. The seller can sign an annexure saying this agreement of sale will be subject to purchasing a property or renting a property.
Yes, because I know sometimes sellers are concerned that when they find a buyer and they're like, now whatever, I'm not going to have a place to buy or a place to live in. So then those annexures would come into play, basically.
That will protect the seller.
Yes. Okay. All right. Okay. Then, can you give us some brief advice on late estates? So late estates refers to properties where, like I said earlier, when one or both of the sellers either pass away prior to the house being sold or during the actual sale process. What kind of advice would you offer to sellers or members of family that are now selling this property?
Okay. So when a relative passes away, it's very important to first and foremost report the estate to the Master of the High Court. The Master of the High Court will then issue letters of executorship. So the heirs, the family of the deceased, can't enter into an agreement of sale without the letters of executorship. So the letters of executorship needs to be issued before an agreement of sale can be signed. The heirs are not empowered to sign any agreement of sale. When entering into a transaction with a deceased estate, with an executor of an estate late, it's very important to make sure that all heirs are in agreement with the sale, so that because all heirs to the estate needs to consent to this agreement of sale and the sale.
So it's very important that you actually get that actual executor document,
letters of executorship,
before you even list the property.
Correct, yes.
Because it will just create delays further down the line.
Yes. Remember, if agreement of sale is entered into without the letters of executorship being issued, then the agreement of sale
It's actually not even valid.
is null and void. Yes.
Okay. Alright. Do your offices deal with commercial and residential properties, or only residential?
So we deal with commercial and residential properties,
Mhm.
but I would say the majority of our transactions are residential properties because of the area where we base.
Okay, understood.
Okay.
Yeah. So almost there. Just two more questions. What are the costs if a buyer or seller cancels a sale? So whether it's right at the beginning or midway or even at the end, or what are the costs?
So it's very important to remember that a seller and a buyer doesn't have a right in terms of an agreement of sale to cancel
Okay.
for no reason.
Yeah.
Okay. A seller or a purchaser can only cancel an agreement of sale if there has been a breach of agreement
Mm.
of the terms of the agreement by another party.
Okay.
So if the purchaser commits a breach of the agreement of sale, does not fulfill the obligations in terms thereof, then the seller would be entitled to issue a letter of demand asking the purchaser to comply with their obligations in terms of the agreement of sale. And if they do not comply, then the seller would be entitled to cancel the agreement of sale.
Okay. Because the buyer is not
In breach.
sticking to what they promised, basically.
Yeah.
Okay.
So once the agreement of sale is cancelled, then your party that was in breach is maybe liable for damages if the seller suffered damages.
Yeah.
But damages needs to be proven in a court of law. Okay. The estate agent in concern would also, in the instance of a breach of contract, be entitled to claim their commission from the party that is in breach of the agreement.
Okay.
It sometimes happens that sellers and purchasers decide mutually to cancel an agreement of sale.
Oh.
Yes.
Like behind everyone's back, that is it.
Yes, yes. There might be circumstances that arise that prevents them from continuing with the transaction.
Okay.
Okay, so the seller might not be able to find the property and the purchaser's circumstances might change and then they don't want to purchase the property anymore. And then they decide mutually to cancel the agreement of sale. And in those instances, the estate agent would also be entitled to
the commission
still.
So wouldn't that mean they need to split then? If they both agreed to it? Or who then still pays?
They would normally then settle the matter by agreeing on who will pay the estate agent's commission. Okay. So it's very important to consider that. Then also further cost involved when an agreement of sale is cancelled. The attorney, the conveyancers involved.
Yes, of course.
They will be entitled to claim wasted costs from the party that is in breach of the agreement.
Of course, because you've been doing work in the background.
Yes, that's correct.
Correct. Okay, I think there was another question that you mentioned you wanted to... Okay, now we spoke about that. So, many times, so in South Africa, and I'm not sure if it's international law, but in South Africa, the seller gets the opportunity to decide which attorney is going to be used for the actual transfer process. With the bond attorneys, that is decided by the banks, correct?
Correct, yes.
So sometimes the buyers would want to use their own attorneys, and in some instances, sellers are okay to use the choice of the buyer. And there are on occasion, of course, where buyers are requesting discounts on the actual fees. Do you guys offer discounts on certain occasions, and what are the kind of discounts? Just percentage-wise, obviously, for the purpose of this question.
Okay. Yes, so the conveyancing fees, our firm charges conveyancing fees in accordance with the guidelines issued by the Legal Practice Council. And we do offer discounts to purchasers on request if there is reasonable grounds for it. Our discount will also be a reasonable amount. And the discount that we offer would depend on the amount of would depend on the business relationship we have with the purchaser. If the purchaser refers further business to our firm, then obviously we have to we have to consider that and grant to the purchaser discount. And also we have to consider the purchase price, because remember the conveyancing fees are works on a sliding scale. So the higher the purchase price, the higher the fee.
Correct. Yes.
So if it is a higher purchase price, then the discount might be more. But I would say an average of about 15%, 10% discount is what we can do on transfers. The banks offer bigger discounts to the clients in respect of the bond.
Correct, because that's normally also arranged when you're in the process of getting your final bond grant, and then the banks will offer different discounts or reduced rates. So that normally happens at that process, correct? Before you get the actual final bond grant.
That's right, yes. So the bank will instruct their panel attorney that the purchaser qualifies for a 50% discount on the bank scheme.
Okay. I think that we covered all the questions. Is there anything else that you maybe want to add that I didn't ask?
No,
I think we covered pretty much everything.
We covered everything.
Okay. So thank you very much, Christu. I really appreciate that you're on the channel. I'm so chuffed, and I just realized now as I'm watching, I didn't even know that I'm matching the actual decor of the company. So that's so cool.
That's all for today's episode. Next week we'll have part 2 of the transfer process, and I will chatting to one of Gravenstein's conveyancing paralegal. I'd love to see your comments below on any of the points mentioned today that you found informative. Until next time, thanks for watching Your Property Journey.